Assalamualaikum warahmatullahi wabarakatuh. My name is Helmi and I'll be presenting this topic on behalf of my team member as well, Dr. Zahari. And this exploratory research entitled Animal Created Works from the Lenses of Copyright Law. So the theme of this research revolves around the concept of authorship under copyright law, and I'll be explaining that concept in a short while. And I think I should start with the objectives of copyright law, of this particular legal framework. Copyright law aims to achieve these three objectives. And if we look at these three objectives, they can be easily connected to human being as creator of the work. Now, when it comes to the animal kingdom, i.e. animal created works, this is where the boundary of the concept of authorship is tested. So for your information, in the copyright context, authorship concerns the aspect of who creates the work. And in this situation, it gives rise to several questions. So among others are, can these animals, chimpanzee, elephant here, can they be regarded and recognized as an author from the perspective of copyright law, and who will be owning these artworks? This made us think the very basic question, can an animal own a copyright? And in order to answer this question, we have to know whether an animal can be recognized or can be regarded as an author or creator, or in Bahasa we call it as pencipta karya. And this aspect is crucial, important, because the initial or first copyright owner of a work is usually the author or the creator of work himself. And to answer this question, we combine doctrinal and library-based research because it involves the analysis of legislative text and case law and the understanding of basics and fundamentals of issue under investigation. This, I would say, this is the most famous and interesting case when we talk about animal authorship, famously known as the monkey selfie case. It was brought before the US courts in 2015 concerning this very image, this selfie. So what happened was we have David Slater. He's a photographer. So he went to Indonesia to take photos of monkeys. And suddenly a monkey named Naruto, our friend here, Naruto used David Slater's camera to take its own selfies. And then David went back to his country, published a book containing a number of images, including this particular selfie. PETA then sued David Slater as next friend of Naruto. So PETA was arguing that it is Naruto. Naruto was the author or creator of this image, and presumably, allegedly, also the copyright owner of this particular selfie. And Naruto and PETA argued that David had committed copyright infringement by selling something which is not his, because PETA thought that David is not the author or creator of this work, and David had actually sold something which is not his, and therefore that's practically a copyright infringement. And David then counter-argued, claiming that Naruto is just an animal, a monkey, and therefore cannot be regarded as author or creator of a work under the US copyright law. And then they argued, and this case went even up to the US Court of Appeal. And the first court decided that Naruto was not an author of this particular selfie under their respective copyright law. And the court was of the opinion that the Copyright Act does not plainly extend the concept of authorship to animals. So in other words, their Copyright Act does not expressly extend the concept of authorship to animal kingdom, and hence we cannot regard or recognize Naruto as the author or creator of this particular selfie. So PETA then appealed to the Court of Appeal. Unfortunately, the Court of Appeal also gave the same answer. Naruto, the monkey here, is not the author or creator of the work under their copyright law. There are a number of justifications and reasonings. The court look into the language of the US Copyright Act, and the court found several phrases: children of an author, widow of an author, and these phrases basically imply that author is and must be and should be a human being, not animal, because animals do not marry and animals do not have descendants or heirs to inherit properties from their fathers and mothers. So basically, in short, the courts in this particular case opine that Naruto cannot be regarded or recognized as author or creator under their copyright law. Now, these are among other important legislative texts from the United Kingdom, for instance. Basically, all these lead to an understanding that to attract a copyright protection, the work must be created by human being. In other words, the creator of a work must be a human being and not an animal. Now, this is a what-if situation. What if we still recognize animal as author or creator under the Copyright Act? So what is the position if we are to do this? Matthew Hooker in year 2020 states that if the Copyright Act recognizes animals as authors, their works would become stagnant. In other words, their works cannot be further exploited or used because of the nature of animals. They cannot bargain, they cannot enter into contract, they cannot participate in licensing activities. So Hooker was trying to say that it's useless, it's purposeless if we are going to give some rights to animal to be recognized as an author, but they can't do anything with their works. And in the end, it's going to be defeating the purpose of copyright law if their works cannot be further exploited. Because the purpose of copyright law is to promote or support the dissemination of knowledge and progress of arts. So it's like useless if we are going to recognize an animal as the author or creator if they themselves can't actively participate in the transactions, commercial transactions, especially in selling or licensing their works. Now, if we go back to the question that I posed earlier, can an animal own a copyright? So the answer is negative. No, an animal cannot own a copyright. And in most jurisdictions, the law requires authors to be a human being. Now, that's an interesting question. Is it still possible? Uh, is it possible if we are to proceed to recognize animal as author or creator of the work? And based on our searches, we found two major opinions, dua mazhab berkenaan dengan premis sama ada apakah yang akan terjadi ataupun bolehkah kita masih memberikan haiwan sebagai pencipta karya. A strict approach, they say no, animals cannot be author, so that's that. Their works shall be part of public domain, which is free to be used by any interested party. So that's a very strict point of view. But we have a less strict view as well, proposing a sui generis model. So basically, this model proposes that the trainer of the animal to be recognized as the agent, and any income generated from the use of the animal created works should be used for the purposes of animal welfare. And we think that the second approach is preferable because it's like I think we think that it's possible to strike a win-win situation. So basically that's about the presentation, and we hope that you benefit something from this brief presentation on our research, and thanks for listening. Assalamualaikum warahmatullahi wabarakatuh.